Hello everyone and welcome to our channel Project Management and Control. This is my second video series related to preparing of extension of time claim for a contracting firm. Before I start, I will recommend you guys to take note from this video, which will definitely help you while you are preparing your own claims. So I will explain the contents of the minimum contents of the claim. I already explained in my previous video one of the content of the claim, which is executive report. Kindly visit the channel for the full detail. So to repeat again in a while, extension of time claim consists of minimum of the following. Number one is the executive report. Executive report already defined in my previous video. Overview of the number two is overview of relevant contract clauses. Number three is delay and disruption events. Number four is delays assessment methodology. Number five is summary of delays analysis and EOT entitlement. Number six is mitigation measure, and then number seven is appendix. So in this video, we'll see what is the overview or relative contract clauses which will support or give rise to contractors' claims. So before we start, we'll see the contractual requirement. The contractor is entitled to an extension of time EOT to the original time for completion in the events that progress of the work is or will be delayed due to cause beyond the contractor's control and despite contractor's best efforts endeavored to avoid their impact or to mitigate such delay as much as possible. The contractor is entitled for the extension of time claim under the following clauses. Refer here that we are referring here the condition of contract clause FIDIC 1999. So we are referring to FIDIC 1999. So in FIDIC 99, the following clauses are contractor claim is based on the following clauses. Number one is subclause 1.9, which is related to delayed drawing or instruction. Subclause 2.1, which is related to right of access to the site. Subclause 3.3, which is instructions to the engineer, instructions of the engineer. Subclause 4.7, setting out. Subclause 4.12, unforeseeable physical condition. Subclause 8.4, extension of time for completion. Subclause 8.5, delay caused by authorities. Subclause 8.8, suspension of work. Subclause 8.9, consequences of suspension. Subclause 13.3, variation procedure. Subclause 13.5, provisional sum. Subclause 14.6, issuance of interim payment certificate. Subclause 14.7, payments. Subclause 14.8, delayed payment, and subclause 20.1, contractor's claim. Now we will see all these clauses in a brief. The first is subclause 1.9, which is related to delayed drawing or instruction. This clause stated that the contractor shall give notice to the engineer whenever the work are likely to be delayed or disrupted if any necessary drawing or instruction is not issued to the contractor within a particular time. The particular time means that there are drawing or session to be issued between the early start and late finish. If it is issued after late finish, the contractor shall give notice to the engineer for the possible or expected delays. The other clause is subclause 2.1, which is related to right of access to the site. This clause stated that the employer shall give the contractor right to access to and possession of all parts of the site within the time stated in the appendix to tender. The right and possession may not be exclusive to the contractor. This clause is specified that if the contractor suffered delays and or incur costs as a result of failure by the employer to give any such right to or possession within such time, the contractor shall give notice to the engineer and shall be entitled subject to subclause 20.1. The dear engineers, just follow that in both these clauses 1.9 and 2.1 mention that contractors have to give notice. So be careful and try to raise notice as early as possible. The other subclause 1.9 and 2.1, the other clause is that subclause 3.3, which is instruction of the engineer. The engineer may issue to the contractor at any time instruction or an additional or modified drawing which may be necessary for the execution of the work and remedying of any defects. The other clause is our 4.7, which is setting out. This clause stated that the contractor shall set out the work in relation to original points, lines, and labels of the reference specified in the contractor or notified by the engineer. The contractor shall be responsible for the correct positioning of all parts of the work and shall rectify all error in the position. In this, according to this clause 4.7, setting out that if the contractor suffered delays and or incur costs from executing work which was necessitated by by an error in these items or references, and and an experienced contractor could not be reasonably have discovered such error and avoided this delay and or cause, the contractor shall give notice to the contractor. The other clauses which is here is clause 4.12, which is unforeseeable physical condition. This clause is stated that in that the physical condition means any natural physical condition and man-made another physical obstruction and pollutants, which the contractor encounter at the site when executing the work, including subsurface and hydrological condition, but excluding the climatic condition. The other clause is clause 8.4, which is extension of time for the completion. This clause stated that the contractor shall be entitled, subject to subclause 20.1 contractor's claim, to an extension of time for completion, or if and to the extent that completion for the purpose of subclause 10.1, which is taking over of the work on section, is or will be delayed by any of the following. Number one, a variation. Number B, a cause of delay which giving an entitlement to extension of time under a subclause of these conditions. This here we clause point B is referred to subclause 1.9, which is delay during instruction. Subclause 2.1, right of access to the site. Subclause 3.3, instruction to engineer. Subclause 4.7, setting out. 4.12 for unforeseeable physical condition. Subclause 8.5, delay caused by authorities or any other delay event, and subclause. So other clause is 8.4c, exceptionally adverse climate condition. 8.4d is unforeseeable shortage in availability of personnel or goods caused by epidemic or governmental actions. And the last 8.4e is any delay, impediment, or prevent caused by or attributable to the employer or employer's personal or employer's other contractor on the site. So in this, the contractor is entitled for the extension time under this clause 8.4 A, B, C, D, E. We have to check that which is referred to and suited to us. For example, if our project is delayed because of delay during instruction, we can refer 8.4 B, which is a cause of delay and given entitlement to the extension of time under subclause 8.1.9 delay during instruction. So we can write like this. And you can see that 8.4 stated that if the contractor consider himself to be entitled to an extension of time for completion, the contractor shall give notice to engineer in accordance to subclause 20.1. When determining such extension of time under subclause 20.1, the engineer shall review previous determination and may increase but shall not decrease the total extension of time. The other clause is 8.5e, which is delay caused by authorities. In this subclause, stated that if the following condition apply, for like the contractor has diligently followed the procedure laid down by relevant legally constituted public authority in the country, these authority delay or disrupt the contractor's work, that the delay or disruption was unforeseeable, then the delay or disruption will be considered as cause of delay under subclause 8.4b. So you can see that we can if we are getting delay because of any authority, we can claim this clause under 8.4b. So this will be considered under 8.4b as 8.5. So we will claim 8.5 under 8.4b clause. And the other is subclause 8.8, which is suspension of the work. The engineer may at any time instruct a contractor to suspend progress of part or all of the work. During such suspension, the contractor shall protect, restore, and secure such part of the work against any deterioration, loss, or damages. The engineer may also notify the cause of suspension if and to the extent that the cause is notified and is reasonably and is the responsibility of the contractor. The following subclause 8.9, 8.10, 11 shall not apply. So the subclause 8.9 is consequences of the suspension. If the contractor suffered delay and or incur costs from complying with engineer's instruction under subclause 8.8 suspension of work and or from resuming the work, the contractor shall give notice to engineer and shall be entitled subject to subclause 20.1. The other cause is that 30.3 variation of procedure. If the engineer requested a proposal prior to instructing a variation, the contractor shall respond in writing as soon as practicable, either by giving reason why he cannot comply or by submitting the following documents. The other clause is 13.5, which is provisional sum. Provisional sum stated that each provisional sum shall only be used in whole or in part in accordance with the engineer's instruction, and contract price shall be adjusted accordingly. The total sum paid to the contractor shall include only such amount for the work. So the extension time claim can be contractor can be claimed extension time for sub clause 13.3 and 13.5, and these two clauses also be claimed under 8.4b. So other is 14.7 related to payment. The employer shall pay to contractor the first installment of the advance payment within 42 days, and the amount interim payment, and 14.7b stated that the amount certified in each interim payment certificate within 56 days after the engineers receive the statement and supporting documents. So we have, while we are reviewing this condition 14.7, we have to pay attention to particular particular contract condition, because this number sometime modified in the particular condition. So before implementing or apply, if you are engineer, we are checking the contractor's payment or contractor's claims, so we have to check that this number mentioned in FIDIC 99, it should be matched in the particular condition, because sometimes the employer changes this number. For example, he may say he can contractor the employer can say that the first installment of the advance payment within 60 days. So we cannot tell anything to contractor employer, because he already mentioned in that the first installment will be paid in 60 days. So before 60 days, the contractor has no right to complain. The other clause is 14.8, which is related to delayed payment. So this is if the contractor does not receive the payment in accordance with subclause 14.7, the contractor shall be entitled to receive financing charges compounded monthly on the amount unpaid during the period of delay. This period shall be deemed to commence on the date for the payment specified in subclause 14.7, irrespective in the case of subparagraph B, or of the date on which by interim payment certificate is issued. So you can see that the contractor are entitled for the claim of extension time because of the delayed payment. Because of this delayed payment, contractor may say that he is not able to pay the subcontractor or supplier on time, or to stop on time, because of which the people are leaving the site, and he is not able to bring more people because of the lack of cash flow. So these are the conditions you can see that which help the contractor to prepare his claim. So now you can see we see that our the contractor's claim are based on the following condition of contract, subclause 1.9, 2.1, 3.3, all, and this is all related to the our contents of the claim. So now we have covered our two topic: executive report, overview of relevant contract clauses. Our executive report already discussed in the previous video number 1, and this video cover overview of relevant contract clauses. In next video, I will try to explain what are the delay and disruption event, how to define this event, delay assessment methodology, and summary of delay as analysis, and UT entitlement, then mitigation measure, and appendix. So till next time, see, I hope this video is helpful for our fellow plan engineer. And if you like it, please like, share, and subscribe the channel, and share this video with the other fellow plan engineers for their understanding, and to start preparing their claim. So please like, share, and subscribe. See you soon in the next video. Till that time, thank you very much for your time. Take care, and bye bye.